have missed any of those, just send us an email, info@theknowledgegroup.org, and you can still get your questions in using that Q&A tab. The questions will come straight to us, so don't worry if they don't appear. But John, perhaps you want to lead us off with this question. Patricia, you're more than welcome to give your input as well, but it did drop in during your segment. John, do you think trial strategies will be changing given the possibility of remote trials or maybe even socially distanced trials in person? And how do you feel like these strategies may evolve as the landscape's changing there?
Sure, I think that's a fair question. My view is that trial strategies will change, although I still think that there will be time-tested strategies that will play to live juries just as virtual juries the same. Some of the things that I mentioned, I think, would apply perhaps to both. But in the focus groups that I've been involved with judges and lawyers who have done virtual trials, and I haven't done a trial, done other things virtually, there's a couple of principles to take away. Number one, jurors actually seem to be more comfortable in the setting of a virtual trial. They're in their homes typically. They're in a better setting. And folks are finding that they're more focused and they're paying attention to things more than they would perhaps when they're in uncomfortable settings, which I think is an unusual finding. And so the trial strategy sort of there is perhaps you can lighten up on some of the repetitive trial themes if you feel that your jury is more focused and getting the points more quickly than they would in a big courtroom in an uncomfortable setting. I think, secondly, the big takeaway is jurors seem to not be able to react or consider the theatrics that often happen in the courtroom. Body language, things along those lines are limited, obviously, in a virtual trial. And so the other things that the jury can see become all that more important. Your witness's facial expressions are all that the jury sees now. Your own facial expressions are all that the jury sees. And demonstratives that you use in the trial will be particularly important because that's all that the jury is seeing at the time that you're using them.
Thank you so much. And Patricia, I want to try and squeeze in this question here for yourself. What are your thoughts when it comes to objections? Do you make them in open court or at the bench? And why would that be? And have you found in virtual trials perhaps the stance on making objections might be somewhat different to an in-person trial?
Sure. So especially in the beginning of a trial, my perspective is that I try to make objections at the bench. But if opposing counsel, and that way the jury is not hearing, they're not hearing more than they need to hear, and the court can quickly resolve it. But if an opposing counsel continues to try something that I find offensive or objectionable, and it's not conveying to the judge at the bench conference, then I may make the objection out loud and have not a full-on speaking objection, but I will try to give an idea of the issue so that the jury is aware, especially if I think that it's going to have if it's a significant issue that could impact the outcome of the case. And then regarding the virtual setting, I think it actually would be a little easier. It would be a little easier to have these side conferences with the judge, and I would probably be more inclined not to do that in front of the jury because of the technology and it's the fact that it permits the parties to step aside and talk to the judge and not in front of the jury. I think that the jury could probably be offended by that, knowing that we have the ability not to do that in front of them.